So welcome to the Employment Right Bill Advisory Series. My name is Louisa Weinstein. Due to unforeseen circumstances, it's only me from the IR, the Industrial Relations team at the JIB today. But we are here to support you with all your JIB industrial relations needs, and we'll make sure that we give you the new telephone number at the end, which hopefully you should have already, and you can email us. Now, there may be questions that come up today. Please do post those questions in the Q&A. I may be able to answer some of them as I go, but I'm more likely to answer most of them at the end of the session, just to make sure that we get through all of their content. There's quite a bit to be getting through today. So I'm just checking the attendees, and just to be sure that everyone's safely in before I start. Lovely to have you all here. Okay, fantastic. Thank you. So the Employment Rights Bill. A little bit on the Employment Rights Bill in terms of history. Well, recent history. It was introduced to Parliament in October 2024, and it's going through Parliament currently, due to be enacted over the course of 2026 to 2028. The bill may therefore be subject to change. We've already seen a little bit of change. And so many, albeit not all of the things that we're going to talk about, will stay consistent, but some, as I say, will be subject to change. I wanted, before I started, to give you a bit of context. The CIPD Workforce Index 2024 highlights the factors that employees most value in their working lives. And these findings provide a really useful lens for assessing the continuing relevance of the JIB handbook, particularly as getting the right employees is so important right now. So 5 key themes stand out, and they are conflict management, fair pay, meaningful work, well-being, and autonomy with opportunities for development. Those are key issues. So first, the index shows that 1 in 4 employees experience conflict or abuse at work, with such experiences strongly linked, obviously, to dissatisfaction, ill health, and staff turnover. So the JIB is really well placed to address this challenge in particular, as its independent resolution procedure already provides employees with a structured recourse from day one. And we'll talk a little bit more about that later and how that also massively benefits employers. Secondly, fairness in pay and security of employment remain central workforce expectations. The index reports that only about half of UK employees believe that their pay matches their responsibilities, and the JIB already surpasses this benchmark through transparent wage scales, guaranteed working hours, and contractual security. And these provisions provide a distinctive employee value proposition. Thirdly, employees increasingly seek meaning and recognition in their roles. Nearly half now view work primarily as just a source of income rather than a source of inspiration. And the JIB model contributes really positively to this by embedding structured apprenticeships, many of which you provide online. Also, defined career paths and collective recognition of industry standards. And fourth, the index underscores the importance of well-being and manageable workloads, with conflict and overwork linked to negative health outcomes. Here, the JIB again compares favourably, or JIB employers, you compare favourably, offering a shorter 37.5-hour week, enhanced sick pay, overtime protections, and finally, let's move to autonomy and development, which also remain high priorities, Many employees report monotonous work or underutilization of their skills. The JIB framework already addresses this through apprenticeship training, the experienced worker assessment, of course, and structured career progression, which is so valuable and so important to individuals. So, in summary, the CIPD findings demonstrate that the handbook already meets many of the workforce's big wants. The tribunal is already the tribunal system's already under strain with waiting times for a single claim to get to tribunal at about 12 months. Now, ACAS, who we heard from at the London Forum, London South East and Southern Forum, is likely to be already under pressure and under a significant, dealing with significant caseload. And both of those pressures are likely to increase with the advent of the Employment Rights Bill, which is going to mean that things are going to take longer. So the JIB, through its resolution process that we'll talk about, and more importantly, JIB employers and operatives, but the JIB is able to provide stability, swift turnaround, and early resolution, so no interruptions in the industry at a time when delay is one of the biggest risks to productivity. So let's get into it. It's important, really important to note that the current Employment Rights Bill, as of, as we've said, it's updating regularly. So as of, say, September 25, constitutes a very high level scoping bill, which will be rolled out over a 36-month period. And during this period, the government have committed to consulting with businesses to finalise the nuances of the enhanced or new rights. And there are many. And then these rights will be formalised and introduced to the statute books by way of statutory instruments. So we plan to keep you updated as those changes affect the handbook along the way. So during the course of next year, during those 4 parts. And what we'll do in these updates is provide a guide through the changes as they relate to the handbook and where action might need to be taken by you as JIB members. Just also to highlight that in terms of time frame, royal assent should have been given in October, so timeframes are slightly delayed, but we'll keep you abreast of this as much as possible. So just let's look at the JIB handbook in the context of employment law and how the two come together. As we know, the handbook is a comprehensive collective agreement establishing terms and conditions of employment for the electrical contracting industry. The terms have been negotiated and agreed between the Electrical Contractors Association on behalf of electrical contractors of all sorts of different sizes and shapes, and Unite the Union. Now, we know that employment law sets statutory minimums and applies across all industries. It's often driven by government priorities and is subject to statutory process. So you've got a situation where the handbook is really specific to the specific needs of the industry, and you'll know that they are many and they are detailed. So these industry-specific standards that are delivered through the handbook often exceed the legal minimum. But what's also important is that handbook evolves through the collective bargaining, through the continuation of the conversations and negotiations and relationship between the Electrical Contractors Association, the ECA, on behalf of employers, and the Unite the Union, so that the terms of the collective agreement are constantly tested and then enforced by people who understand specifics through the resolution process. Coming on to the Employment Rights Bill, it's one of the biggest updates to UK employment law in a generation. And it is it's come in as part of the government's Make Work Pay agenda. So the bill is designed to modernize the workplace, tackle insecurity at work, and ensure that core protections apply from day one so that people are comfortable and happy and want to be employed. It aims to make work more predictable, more family friendly, and fairer for both employees and responsible employers. In total, the bill introduces around 25 to 30 major reforms, including several completely brand new rights and many extended protections. So I'm going to give you headline changes. First, day one rights to claim unfair dismissal, parental leave, and paternity leave. And you'll have seen that those one rights relating to unfair dismissal, the boundaries have kind of changed around that over the last week or so. So we'll dig into that a little bit and how that relates to the handbook. Also, continue with headline changes, stronger protections for 0 hours and irregular hour workers, including the right to a contract that reflects regular hours and compensation for late cancelled shifts. There's also statutory sick pay from day one with expanded eligibility, limits on fire and rehire and unfair contractual changes, stronger redundancy consultation rules, including higher protective awards, and enhanced trade union access and worker voice obligations, as well as updated protections against workforce harassment. Now, most reforms are expected to take effect from early 2026 to 27, giving employers quite a bit of time to prepare. And bear in mind, obviously, we haven't yet received royal assent. So let's look at the new rights at a very overview glance. They are grouped into the 3 stages of the employment lifespan, really: hiring and onboarding, in-work protections, and then exiting employment. So let's look at hiring and onboarding first of all. So the bill, even with the amendments that have been made so far, brings in a much stronger baseline for workers from day one. We will see day one paternity leave and unpaid parental leave. And employers will also have new duties to inform workers about their union rights and strengthened union recognition processes from around April 2026. Looking ahead to 27, we'll see the gender pay gap action plans, enhanced flexible working rights, and new safeguards for pregnant workers. The bill also introduces regulation of umbrella companies aimed at tackling exploitation in labour supply chains, so really important to the industry. Moving on to in-work protections. Once someone is in the job, the bill significantly increases stability and fairness. There are some major reforms to 0 hours and irregular hours contracts expected in 27, giving workers predictable hours and compensation for late cancellation. Sorry, put my teeth back in. We also see improvements to statutory sick pay, to better pay transparency and strengthened whistleblowing protections. From October 2026, the bill introduces tougher rules on sexual harassment prevention, blacklisting, and detriments linked to union activity. We'll also see the creation of the Fair Work Agency, fair pay agreements, and clearer rights for union access in the workplace. Finally, coming to exiting employment. When the employment ends, the bill tightens fairness and consultation standards. And from October 26, there will be a ban on fire and rehire practices alongside enhanced collective redundancy protections and a lower consultation threshold. We also see extended employment tribunal time limits, new bereavement leave, and stronger protection against unfair dismissal during industrial action. So the bill also repeals the Trade Union Act 2016 and the Minimum Service Levels Acts and brings in electronic and workplace balloting from April 26. So that's a major shift in really modernizing democratic process at work. But let's look at the provisions, oops, excuse me, relevant to the handbook. Parts of the Employment Rights Bill are most relevant to the handbook. We don't have an exhaustive list for you, but what we wanted to do is highlight the areas that will matter most as the new laws come into force. So the areas that are highly relevant, well, you've heard about day one unfair dismissal. Obviously, that has changed and is changing. But I think the important piece around that is not necessarily what happens with the legislation. It's that the JIB already provides access to the resolution process from day one. And as I said, we'll talk a little bit about that later. The point is that this works really well, as I said, for employers and employees in terms of productivity, building a relationship. And we see in practice that it benefits everyone as we see inquiries come in, get resolved, clarifications made, and people able to get back to work. In any event, this is not going to be affected by the changes in proposals for day one rights under the Employment Rights Bill. But I wanted to raise it because there's so much talk about it right now. In terms of statutory sick pay, those reforms may require us to review the JIB sick pay scheme to just ensure compatibility. Trade union access rights will interact directly with the JIB's existing representation framework. The ban on fire and rehire fits very naturally alongside JIB's established dispute resolution process, which already promotes and really has a culture of fair negotiated changes to the employment terms, culture and process and practice. Look at moving to the areas of medium relevance in the Employment Rights Bill to the handbook. Flexible working may require some modest updates to JIB working arrangements. Day one paternity leave will need alignment with the JIB's family leave provision. Collective redundancy reforms may increase consultation obligations for JIB employers. And the new predictable hours rules are expected to have a limited impact as the JIB model already promotes stable standard contracts. So really, a lot of this is covered. The key point is that the JIB framework already meets and in many cases exceeds many of these new statutory rights. So it puts JIB employers in good stead. And for any, I know we've got a few non-JIB employers, you might want to please feel free at the end of the webinar to talk to us about how the agreement can really easily integrate these requirements into terms and conditions. So any adjustments that are going to be needed will be very manageable and largely evolutionary rather than disruptive. I've mentioned day one rights, so I'm just going to talk about that and what that means and how that relates to the handbook. Right now, day one rights are simply protections and benefits that apply from the very first day of employment. So historically, many key rights like unfair dismissal protection or parental leave have required months or even have required months or even years of service. So the bill, well, with respect to unfair dismissal, doesn't remove that qualifying period, but it reduces it. They're saying it's going to reduce it to 6 months right now, meaning, but for other protections, it removes it, meaning that those protections will become available immediately when someone starts work. So just talking through types of day one rights, some already exist today, such as protection from discrimination, right to the national minimum wage, paid holiday entitlement, health and safety protections. They exist from day one. The bill introduces new day one rights. So firstly on unpaid not on unfair dismissal, that is going to be 6 months in right now, as from 2026. But importantly, on paternity leave and on unpaid parental leave. Actually, you know what? Because we're running through, we have a few examples there, but I'm going to come back to that because I want to make sure that we cover everything. So what the bill requires, particularly, let's focus particularly on paternity leave and parental leave, is that paternity leave becomes a day one entitlement, and unpaid parental leave will no longer require a year of service. So these changes come into effect in 2 stages: paternity leave from April 26 and unfair dismissal protection from 2027. What the JIB handbook says is this. The JIB framework is already well aligned with many of these reforms. JIB protections already allow, well, in fact, they'll improve on the proposals. Effectively, the JIB protections allow unfair dismissal claims from day one under the resolution rules. But in reality, what will happen is that there will be conversations that will happen about it. And I'll move it, just to be very clear, very rarely does a dispute mushroom because of the fact that these things are dealt with through the resolution procedure from day one. JIB employers also follow robust established dismissal procedures which meet and often exceed the ERB standard. Main area needing adjustment is parental leave, as I've said, which will need to be aligned with new day one eligibility. So for JIB employers, the practical steps are pretty straightforward. You'll need to update your employment contracts and handbooks and review probationary period documentation and ensure that family leave policies reflect day one eligibility. These should be manageable changes. And so you're in a strong position as a JIB member for compliance. Moving to flexible working, and again, I'm not going to linger necessarily, sorry, just checking on questions, but no, moving on to flexible working, I just wanted to give a kind of picture of what that means for those of you who may not, who may need a refresher on that. So it's really about giving employees more choice over when, where, or how they work, so they can better balance work and personal life. It's not just about working from home, which obviously in this industry is pretty much impossible. Rather, it covers a wide spectrum of arrangements that can support different life circumstances while still meeting organizational needs, which is, of course, key. So let's just think about it for a bit. Types of flexible working. We generally, when we talk about flexible working, talk about 2 broad categories of flexibility. Firstly, time-based flexibility, so such as flexible start and finish times, compressed hours, part-time roles, job sharing, and term time working. And then we talk about location-based flexibility, so remote working, hybrid working, mobile site-based working, satellite offices, hot desking. And then, so let's bring this to life in a bit of a real-world example. An electrician with school-aged children might shift their hours to start earlier and finish earlier to accommodate, say, school runs. A project manager may choose compressed hours and have, longer days, 4 days a week instead of 5 standard days, 4 longer days instead of 5 standard days, basically. A designer might use hybrid working, spending part of the week in the office and part at home. And in job sharing, two experienced electricians could split one full-time role, ensuring continuity through regular handovers. Now, obviously, some of those apply and some of those don't. So under the bill, employees have a strengthened day one right to request flexible working. So employers need to consider alternatives if they can't approve a request outright. So employees will be able to make two requests per year instead of one. The employer decision timeframe is also being shortened from 3 months down to 2 months. And those changes are expected to take effect from 2027. So again, lots of time to think about it, lots of time to work it through, and lots of time to see how that would work or not for the business operations. Let's just look at what the JIB handbook says. Excuse me, that the agreement is already well aligned really with this direction of travel. It currently supports flexible working requests after 26 weeks of service and encourages dialogue between employers and employees when exploring those workable options. Dialogue is everything. And as I said, well, I haven't necessarily said in this webinar, but generally, when matters come through the resolution process, or even when they come through to informal conciliation, they're resolved in generally 24 hours or maximum a week. So sometimes these dialogues are tricky, but they get resolved. The agreement also promotes alternative working arrangements where they're operationally viable. So what that really means, because of that operational viability as much as anything else, is that the impact is moderate. You will need to review and update flexible working policies. You'll need to adjust request handling procedures for day one eligibility and ensure supervisors understand how to explore constructive alternatives when a request can't be accommodated. And that might be key. The overall changes should be manageable, and they offer a good opportunity to really showcase progressive, attractive working practices across the industry, so that your employers are working hard to do the right thing, but also providing you with a framework so that operational productivity and practices are fully taken into account. Moving to predictable hours, just a reminder that any questions or queries or your experience would also be really, really welcome. If you've got current experiences of that working well for you, then we'd love to know that in the chat. You might be able to hear that my voice is getting a bit croaky, so I will speak quickly before we goes. Okay, let's move on to predictable hours. So predictable hours means that employees have clarity about when they'll work, how many hours they'll work, with schedules and minimum hours set in advance. This is not something new to the industry. While many traditional roles offer this kind of arrangement, variable or 0-hour contracts have grown in recent years. You will know that, employers will know that very, very well. So, and operatives will know that well, because it creates uncertainty around income, around shift patterns, around work-life balance. None of which is what most people want nowadays. There's a lot of demand, as we're hearing it, for certainty, for clarity, for stability. So the bill aims to address this by giving workers in unpredictable roles the right to request a more stable, predictable pattern of work. Key characteristics under predictable working hours, under predictable working patterns. What you'd expect is what you'll often have on a JIB job, which is fixed start and end times, guaranteed weekly minimum hours, advance notice of schedules, consistent weekly patterns that support that stable income that people want. Unpredictable hours often involves a variable start and finish times, no guaranteed minimum hours, last minute shift changes, weekly income that fluctuates dramatically. So so obviously the JIB agreement accounts for 37 and a half hours, but let's look at some real world examples. A standard 40-hour non-JIB contract is predictable. The employee knows their hours and they can plan life around them. A 0 hours worker, however, may only get their schedule a few days before, and their hours may change during the week or weekly. Agency workers also often face irregular assignments and inconsistent hours. So under the new reforms, they would be able to request guaranteed minimum weekly hours and greater advance notice. So it becomes more attractive to kind of have these pieces in place already, because flexible working is becoming for employers is becoming less flexible. The bill introduces a ban on exploitative 0-hour contracts, so that it's it's less easy to have contracts that don't provide a guaranteed income. So it's forcing employers to move more to a kind of standard defined employee relationship. Workers on variable hour arrangements will be entitled to request a contract that reflects the hours that they actually work, rather than being left with uncertainty. And employees will also gain the right to reasonable notice of work schedules, plus compensation if shifts are cancelled at short notice. So both the predictable hours measures and the agency worker reforms are planned for implementation in 2027. So these changes target the insecurity created by irregular working hours, contrasted by the security of a JIB employer. The aim of the changes in the bill is to prevent employers from avoiding responsibilities through contract structures that create precarious employment, while still allowing genuine flexibility where it's needed. So let's look into what the JIB handbook says. The national working rules, as you'll know, if you are a JIB member, set out standard contracts with predictable hours, guaranteed working time. So it's all there. It's anticipated, the need for stability. 0 hours contracts are not a standard feature of JIB electrical contracting. So, very, very much the industry is already well aligned with the direction of travel of the legislation. Just thinking a little bit about what this means for JIB members. The changes that JIB members will need to make are modest. You will need to review any non-standard or variable hours contracts that you do use, and prepare for a shift away from arrangements like this. You will need to just update or make sure that your contract templates are updated to reflect those guaranteed hours requirements. It's also going to be really important to monitor official guidance as we approach the 2027 implementation date, and we'll hope to keep you updated of all of that. But overall, you'll be able to see that the JIB framework already places members well ahead of these reforms. Just moving to the JIB resolution process, and I will share just a different screen possibly in a little bit, just to highlight that process. But we will also be sending you a kind of clear outline of how the process works and how to engage with it following this webinar. Very simply, the resolution process provides a free, voluntary, confidential service that's designed to resolve disputes early. It's available to operatives under the agreement and JIB members under the agreement, and as well as registered apprentices from day one. It does cover dismissals, including redundancy appeals, grievances, including breaches of the handbook, and unlawful deduction of wages. But what it doesn't cover is whistleblowing, blacklisting, discrimination, harassment, health and safety, TUPE or trade union membership issues. Just looking briefly at how the resolution process interacts with the employment tribunal. So ACAS, who, as I think I said, ACAS, who we heard from at the London Forum, London South East and Southern Forum, provides non-industry specific conciliation, and I hope you've seen that through the through this process. One of the beauties of the handbook is that it's industry specific. It looks at the kind of issues that employers and operatives in the industry are going to encounter. It anticipates them. It's thought them through. So ACAS provides non-specific industry conciliation processes, as I've said, and they will often pass, if something comes through to ACAS, they will pass that back to the JIB because they know that our conciliators will be able to deal with it more effectively and quicker because we know the handbook. What just in terms of practicalities, people can lodge a tribunal claim, can go to ACAS at the same time as invoking the JIB resolution process. And they might want to do that because of time limits. And they don't want to inadvertently lose their statutory time limits if they are thinking of or planning to bring a tribunal claim, and that's absolutely fair enough. And ACAS early conciliation is relevant is if a tribunal claim is being contemplated. But it's also important to know that if a tribunal claim is lodged and the JIB machinery is running, so if a claim has been put into the JIB resolution process, then the claimant can ask for any tribunal claim to be held in abeyance pending the JIB outcome, allowing the parties to use the JIB system, but to retain the fallback of the tribunal. And just to put this in context, the resolution process, the JIB resolution process, well, thinking about timelines, generally inquiries or clarifications are resolved within 24 hours, maximum a week. So if something's a little bit more complicated and if there's a requirement for conciliation, that usually rolls through to up to 4 weeks. The ACAS and taking a claim to hearing will take 8 to 12 months. And we know that by that time, the relationship has massively broken down, and the ability to resolve the issue becomes more difficult because with time, the issue becomes compounded. Resentments develop, harm is worsened. So, the main aim of the resolution process is to help deal with things quickly and effectively to reduce harm and trauma for all involved, because it can be traumatic. We know that. Even lasting, anyone who's been involved in any kind of workplace disputes, 24 hours is quite enough to have to deal with that and for it to interrupt people's lives. So never mind productivity and those pieces of business interruption. So it's also important to know that if a dispute is fully dealt with within the JIB system and resolved, the claimant can't proceed to a tribunal for the same issue. So essentially, once it's resolved through the resolution process, it's resolved. It won't then be revisited through the tribunal system. And that's because it will be comprehensively resolved with, really effective conversations and really effective outcomes, trying to achieve best outcomes for all involved. And by the way, this is extremely, extremely rare that a matter would even be considered to go to tribunal after the resolution of the resolution process. But above all, JIB service is free. There are no legal representation costs. Parties are generally represented or sorted or supported by United Union and or the ECA. It's a private process with confidential outcomes, and any hearing is presided over by industry experts. Also, being able to use the mediation and conciliation process really eases the resolution of those issues. So, how to get in touch? As I said, you can call IR as a JIB member or an operative from a JIB company. You can call the IR department at any time for any question, whether it's not quite sure what this piece in the handbook means, to I think I've got a problem, and you can call us directly on this number or email us, and we will do our very best to get back to you within 24 hours. We really want to hear from you as well. We want to know what, if any, provisions are challenging, so that we're aware of your needs, aware of the issues, and aware of where the handbook is clear or unclear. So please make sure you've got that number. You should have that on the JIB website as well. And finally, any questions? Let me see, sorry. Sorry, it's in the Q&A. Oh, interesting question. Can the government confirm whether collective bargaining structures like the JIB will be encouraged as a model for improving paying conditions across the government construction sector? That is a great question, one that I'd love to answer as well. What I can say is that we are engaged with government. The JIB collective agreement is recognised by the people that we've been speaking to, both ministers in number 10, as a really solid form of collective sectoral bargaining. We are going to be responding to we're going to be responding to consultations with respect to collective agreements. And I think the answer to that question is, will collective bargaining be encouraged? I mean, it looks like in the social care sector, they're looking at that model as an effective one. So that says to me that they're looking at expanding the model. And I think that what we can say is that JIB, and I think what they're looking to, what the conversations that we've had have been very much that they are very open to the JIB explaining how well the agreement works and how it works. So as I say, we will be responding to the social care consultation, and we are engaging with government on those discussions. And again, if you want to ask more questions around that, please do connect with us at ir@jib.org.uk. We've got a question here. Nathan, thanks for letting us know that it's sunny in South Wales. That was engagement at the beginning, and I'm very happy to know. And thanks so much for engaging on that one. So, question from Mike Connolly. Hi, Mike. Flexible working raised challenges with holiday allocations. Yeah, we've proposed that any implementations changes are undertaken on a quarterly basis. I mean, just to say that the actual changes won't be put in place for a while. So, Mike, I'd be very interested to have a conversation with you about how you are working that and how that might have an impact for you. But yeah, interesting to know. Thank you. So we've got a question here saying, will reforms affecting training time, paid leave for training, or protections for learners take account of the JIB's nationally recognised apprentice pathways? Again, it's a good question. I would love you to email about that, because I think my reaction is that my initial thought is that the pathways won't necessarily be affected, but I'm not quite 100% sure of the question. I don't think the government is going to go to the JIB handbook and start from there. They'll start from what. So we'll need to look at whether the handbook is affected by those, and we will look at that, and we will come back to you on that probably in future webinars. But my initial reaction or thought is no. I think that my thought is that the handbook again sits above those, but we will update you if there are any issues with that. I don't think that there are. Anonymous said no problem on, I think, yeah, specific, you will have specific questions, and you will be thinking about how things specifically affect your practice, how the handbook specific, how any changes specifically affect your practice. Obviously, the ECA will provide pure employment advice, but we can advise on the handbook. So any questions, come to us and we'll either answer the question now or field you to ECA. The more specific the question you can send to us, the better. I hope that makes sense. Don't want to be too vague, but also I want to answer the question properly. The bottom line is we don't really know what the government's going to do. There were changes as recently as last week. The bill hasn't received royal assent. There will be provisions that will still be going through. So what we can say is that most of the provisions, is what we've said so far, and we will continue to update. But as I say, please do get in touch with specific questions, and let us take a bit of time to think about them and to work them through and to get back to you. It's really, really important for us to get feedback from you at this time on where you're worried, on where you haven't got any clarity. But as I say, ECA will also support companies on this and unite the union on for operatives, and we will put you in the right direction if your questions go beyond our remit. I hope that makes sense. I can't see you all, so it's a bit tricky. That's it for now. I think that seems to be all of the questions. Thank you for your questions. Thank you for joining us from all over the place, including sunny South Wales. Please do get in touch. Any questions, queries, big or small, really keen to hear them. But for now, thank you and goodbye.